The Law of Merger as it affects charges upon land. Part 2. Chapter 1. As to tenants in fee. The merger of charges is a matter purely of equitable doctrine, having no reference to, and being in no respect guided by the doctrines of a court of law. A court of equity will sometimes hold a charge extinguished where it would subsist at law, and sometimes preserve it where at law it would be merged. Lord Loughborough, c. in Lord Compton v. Oxenden, thus states the doctrine: it is a clear principle, both at law and in equity, that where there is a confusion of rights, when debtor and creditor become the same person, there can be no right put into exertion, but there is an immediate merger. But it is true in equity, though there may be that which, if all was reduced to a legal right, would of necessity operate as a merger, this court acting upon the trust will, on the intent, express or implied, preserve them distinct, and that confusion of rights will not take place. The rules which equity has established on this subject affect differently tenants in fee simple, tenants in tail, and tenants for life. With respect to tenants in fee, the rule is, that a tenant in fee paying off an encumbrance must, to make himself a creditor upon the estate, declare by some act that he did not intend it to merge for the benefit of the estate. The presumption of equity is that the charge is extinguished, unless the intention of the owner of the inheritance were to keep it on foot. He has the option of keeping the charge on foot, and may treat it as merged or not, but he must show his intention unequivocally. This rule, however, is modified where the estate is subject to other encumbrances. Merger will not be allowed to take place if the effect of it would be to give priority to these encumbrances to the prejudice of the owner of the estate. The intention need not be expressed by any distinct act or words, it is presumed, and for the purpose of raising the presumption it is necessary to observe whether it was most for the benefit of the owner of the estate to keep on foot or to merge the charge. A person becoming entitled to an estate, subject to a charge for his own benefit, may, if he chooses, at once take the estate and keep up the charge. But in most instances it is with reference to the party himself, of no sort of use to have a charge on his own estate, and where this is the case the charge is held to sink, unless something shall have been done to keep it on foot. The question is always upon the intention, actual or presumed, of the person in whom the interests are united. If the devisee of an estate is also the mortgagee, his entry upon the estate is presumed to be in the character of devisee, if no trace appears of any of the steps usually taken by a mortgagee to get into possession. And if the mortgage would benefit the estate of the owner, there is presumptive intention that the charge should be kept on foot, for otherwise priority might be given to other encumbrances. Where no intention is expressed, or the party is incapable of expressing any, as in the case of an infant, the court considers what is most advantageous for him, and in no case will merger be applied to the injury of the owner of the estate. Where it is perfectly indifferent to the party in whom the interests are united, whether the charge shall or shall not subsist, then it will be held to merge. But if a person, being entitled to a charge upon an estate, and being also owner of the estate at the same time, makes a mortgage in fee, the court will hold that the charge is merged, as it would be a fraud upon the mortgagee to hold that it subsisted, and it is clearly settled that the fact of a charge being supported by an outstanding legal estate will make no difference in the application of merger. Whilst parole evidence is admissible to prove the intention of merger, it has been held that a transfer of the mortgage to a trustee for the owner of the estate, does not afford decisive evidence that it was the intention to keep it on foot, so as to form part of the personal estate of the owner. These are the leading principles which have been laid down at different times with reference to the merger of charges. A short statement of the principal cases will be useful to the reader. One of the earliest cases was Chester v. Wis. Their real estate was devised, charged with 300 litres, by a testator to his son and his heirs, to be paid to his daughter on a contingency which happened. Afterwards the son died, and on his death the estate descended to the daughter in fee, and then the daughter died, but whether underage or not did not appear, without having shown any indication of her intention that the charge should be merged, and it was held that it was merged. And so in Price v. Gibson, where certain premises were devised, subject to a mortgage of 3,500 litres, to the testator's 3 daughters, to be divided equally, and one died. The mortgagee bequeathed to the two survivors all the money due on the mortgage and the interest. The other daughter then died, leaving all her real and personal estate to the third. It was held that the charge was merged in the inheritance. And in Donisthorpe v. Porter, a person was entitled to a sum of money charged upon an estate and secured by a term of years, and afterwards became entitled to the fee simple of the estate, and it was held that the charge was annihilated for the benefit of the estate and heir. The circumstance that the charge was secured by a term of years vested in trustees did not avail to keep the charge alive, and the court observed that, as to mergers, a court of law cannot look into rights or beneficial interests. It merges estates lying in the same person, but cannot where they lie in different persons. Equity does not regard that, but looks into the beneficial interests and views of parties, whether the estates are strictly in the same person or in different persons. In Powell v. Morgan, by a marriage settlement, a term of years was limited to secure portions for daughters. The husband died, leaving only one daughter, upon whom the inheritance descended. The daughter died an infant and indebted, and disposed of the portion by her will. The merger was relieved against, and the portion decreed to go according to the will of the daughter. The facts were very similar in Thomas v. Chemis. A daughter entitled to a portion which is charged upon the estate becomes also the owner in fee. She dies unmarried, having made her will and devised everything in her power to her mother. The court held that the portion was a subsisting charge upon the estate, and ought to be raised and paid. With reference to this and the preceding case, it must be borne in mind that an infant cannot now make a will of personalty, and in Lord Compton v. Oxenden, it is said that these cases of infants turn upon a supposed intent he would have if he could express it. If, however, it be most advantageous to the infant's estate that the charge should be kept alive, the Court of Chancery will preserve it. Lunacy, and therefore the incapacity of an adult person to express any intention as to a charge, will not of itself raise a presumption against merger. If, however, there are debts to be paid, the charge will be kept alive for their payment, and any surplus after payment will then form part of the lunatic's personal estate. Thus, in Lord Compton v. Oxenden, a lunatic died entitled to an estate, and also to a charge upon it, and upon a bill filed by his next of kin the heir was held to take the estate discharged. A trust term to secure charge was held to make no difference, as the trustees could not act except for the purpose of answering the trusts, and these had determined. The case of Gwillem V. Holland, before Lord Hardwicke, cited in Compton v. Holland, is a case which illustrates the rule that merger will not be presumed to the injury of the owner of the estate. Mrs. Holland was entitled to the estate under the will of her mother, and also to a charge on it. She would have taken both equally absolute if her mother had not mortgaged, by which the legal estate was in the mortgagee. It was held to be more beneficial for her to let the estate stand with the encumbrance upon it, than to take it discharged of the encumbrance, and to give a priority to the second encumbrancer. The case of Forbes v. Moffat is to the same effect. A mortgagee became also owner of the estate, which was subject to his and subsequent mortgages. He took possession of the estate, and expended considerable sums of money upon it, and died without having declared any express intention relative to his charge. The question arose between the real and personal representatives of the mortgagee, and it was held that the charge had not merged, as it was more beneficial to let the estate stand with the encumbrance upon it, than to give a priority to subsequent mortgages. The Earl of Clarendon v. Barham, shows to what extent a court of equity will go in holding charges subsisting for the owner of the estate. By a marriage settlement 20,000 litres. The fortune of the wife, was assigned to trustees upon trust, subject to life interests of the husband and wife as to one moiety for the eldest son of the marriage, and as to the other moiety for the younger children. Same settlement a certain plantation in Jamaica, of which the husband was seized in fee simple, was conveyed to the use of trustees for a term of 500 years upon trust, if the husband should so appoint to raise 10,000 litres for his absolute use, and subject to such term and to the life interest of husband and wife to trustees for 1,000 years upon trust to raise 20,000 litres. For the eldest son, 10,000 litres. For the younger children, and again 10,000 litres. For the eldest son, the settlement contained a proviso that the portions should be raised according to their priority, as stated in the settlement. Soon after the marriage, the husband exercised his right of raising 10,000 litres for his own use, and for that purpose the trustees of the 500 years term borrowed of the trustees of the wife's fortune 10,000 litres, and executed to the latter a mortgage of the premises comprised in the 500 years term. The husband and wife died, leaving 5 children of the marriage, the husband having by his will, after directing payment of his debts and devising certain property not situated in Jamaica, devised all his residuary real and personal property to his eldest son, T, and appointed him his executor. Upon the death of the testator, T proved the will, acted as executor, and entered into possession of the estates in Jamaica, of which he kept possession, paying the interest of the younger children's fortunes until 1837, when he became a lunatic, shortly after which he died intestate and unmarried, leaving the 4 younger children surviving him, of whom W was his heir at law. No arrangement had ever been entered into amongst the children relative to the charges in the settlement, nor was there any strong evidence of the intentions of T. As to the extinguishment of those charges to which he was entitled, it was held under these circumstances that the charges were not extinguished in the inheritance, as it was most for the benefit of T. that his charge should be kept on foot. And so also in Davis v. Barrett, a charge was kept alive in favor of the owner of the estate, where, if it had been held to have merged, priority would have been given to other encumbrances. Although the rule which was acted upon in these last cited cases is precise in protecting the owner of the estate from injury, yet it must still be a question what amount of injury is sufficient to induce the court to hold a charge not merged. The injury, be it observed, is that which will or may take place, and not that which has been already sustained. In the cases referred to, although the relative values of the estates and the charges upon them do not appear, yet the presumption may well be, if it is not necessarily so, that the estate in each case was not of sufficient value to satisfy all the charges upon it. No case has occurred in which it has appeared that the estate has been of sufficient value to cover all the encumbrances, and the contention has simply been, who shall be considered the first encumbrancer? The owner of the estate would, it is to be supposed, prevent any such question being raised, by discharging the encumbrances, but, nevertheless, it might be raised, and if the principle is that the owner of the estate shall be protected from all possible injury, he ought to be considered in respect of his charge as a first mortgagee, and in no case should merger be presumed against him. In the case of Richards v. Richards, there are some valuable observations on this point. V. C. Wood, in commenting on the preceding cases, observes, in each of these cases it was held that, there being other charges which, in the event of a merger, would acquire priority, the charge belonging to the owner of the land would not be treated as merged. In a case where the inheritance would be insufficient to cover all the charges, the court necessarily implies an intention that the merger shall not take place. But I do not find it laid down in any of these cases that the court, before implying such an intention, must be satisfied that the encumbrances which would otherwise acquire priority, would exhaust the estate, so far as wholly or partially to defeat the interest which had been merged. In Forbes v. Moffat it did not appear whether the estate would be sufficient, and the principle of that decision seems to be, that, unless you can show that a period existed in which it was absolutely indifferent to the owner whether the charge was kept subsisting or not, there shall be no merger. One can hardly conceive that the doctrine was meant to be stretched to the length that an utterly insignificant encumbrance, as for instance 20 litres, on an estate worth 20,000 litres, will be sufficient to prevent a merger. What was intended, probably, was that there must be some substantial competing charge. Here, the encumbrances which compete with the plaintiff's charge are one moiety of the 5,000 litres, belonging to Mrs. Traherne in her own right, and the half of the other moiety, to which she is entitled as one of her sister's next of kin. It was also mentioned that there was an annuity created by the will of T.M. Richards, which would also be let in priority to the plaintiff's charge. But it appears to me, that, looking at Grice v. Sure, which was rather a strong case, the competing encumbrances being only 2 sums of 200 litres, each, and nothing appearing as to the value of the estate, it would be too much to say that 3/4 of 5,000 litres is not a substantial charge, by reason of which the court is bound to follow Forbes v. Moffat, and that class of cases. I must, therefore, hold that the owner would, under such circumstances, be desirous of retaining his charge. And it is to be observed, that, besides the risk of the insufficiency of the property, there are other inconveniences in having an estate subject to a prior charge. Even where an estate is more than ample to provide for all the encumbrances, it may still be desirable with reference to the remedies which the other encumbrances would have, to stand on an equal footing with them, rather than be the owner of the estate subject to charges, without any right of going in pari passu with the other encumbrances. Having regard especially to Grice v. Sure, I think I am bound to hold, that, although the second son became seized in fee, his interest in the charge remained a subsisting encumbrance, and I decide this quite independently of any equity between real and personal representatives which the court never recognizes. This rule, however, has no application where the owner of the estate and also the charge makes any conveyance or disposition of the estate, whether entitled to the charge at the time of dealing with the estate or acquiring it subsequently. In the absence of any expressed intention, merger will be presumed. Thus in Johnson v. Webster 7a, the devisee in fee of real estates, subject to a trust to raise 6,000 litres, for b, which the testator directed, in the event of B.'s death without children, to sink into the residue of his personal estate and to go to a. On his marriage conveyed the estates to the trustees of his marriage settlement, subject to the trust to raise the 6,000 litres, and died, leaving B. On B.'s death without children, it was held by L.C. Cranworth, that under the circumstances the charge had merged in the inheritance. And where the owner of the estate, and also the charge makes a mortgage, the charge will have merged, as in Tyler v. Lake. There certain deeds were executed by which an estate was conveyed to the use of Catherine Tyler and Charles Henry Tyler as tenants in common in fee subject to a charge of 1,000 litres. A partition was subsequently made under which Mrs. Tyler became entitled to 1 moiety in fee, subject to the 1,000 litres, which was to be charged on that moiety. The trusts of this sum of 1,000 litres were for Mrs. Tyler for her life, and after her decease as she should by will appoint. Mrs. T. then made a mortgage in fee to the Equitable Insurance Society, and it was held that it would be a fraud upon the society to hold that the charge subsisted, and it was declared gone. And if a person entitled to a rent charge, and also to the estate and fee, contract to sell free from encumbrances, as against the purchaser, he cannot say that the rent charge is subsisting, but it will be held to be merged. If, however, the vendor were only tenant for life of the charge, and the legal estate and the charge were both vested in trustees, the merger at law would not affect the equitable interest of the tenant for life, and in such case it would seem a purchaser could not insist upon a conveyance free from the charge. And so a covenant by a person having power to appoint a sum of money as a charge upon an estate that the estate is free from encumbrances, will bar him from exercising that power, and the charge will be merged. Thus, in Gower v. Gower, by marriage settlement J.G. had a power of appointing portions for daughters to the extent of 16,000 litres, under a term of years created for raising the same. He appointed 13,000 litres, part thereof, among 4 of his daughters on their respective marriages, and took assignments from them of their interests in the said term. On the marriage of the eldest son, J.G. and the eldest son covenant that the settled estate is free from encumbrances, and the covenant was held to bar him from exercising the power any further. Again, where a testator devised his real estates to his wife and 3 daughters, A, B, and C, in equal shares, and by a codicil bequeathed 1,000 litres to his daughter A, charged on all his real and personal estate. A married, and her husband joined her in conveying her undivided fourth of the real estate to trustees free from encumbrances by a post-nuptial settlement, which was held not binding on the wife, no fine having been levied by her. The 4th part of the legacy was not merged in the estate devised to her by the will, but the husband, by the settlement, was held to have released a.s. fourth of the real estate from the legacy. Where a person having a partial interest in an estate becomes the owner of a charge upon that estate, and subsequently acquires the fee, it would seem to be doubtful whether merger will take place. In Astley v. Mills, a tenant for life purchased up the charges on the estate and had them assigned to a trustee, and at that time by the rule which equity has established with respect to tenants for life paying off charges, they were subsisting. He subsequently purchased the remainder in fee, and devised the estate, subject to the charges that might be thereon at his decease, and it was held upon evidence of the intention, that the charges so purchased were merged, and so in Lord Selsey v Lord Lake a person having a partial interest in an estate, bought up charges thereon, and had them transferred to trustees for him. He afterwards became absolutely entitled to the estate, and the charges were held to have merged in the inheritance. In Trevor v. Trevor, however, John Lord Hampden being under a settlement tenant for life in remainder, after prior estates for life, and in tail, with remainders to his own first and other sons in tail, with an ultimate remainder in fee, which afterwards became vested in the first tenant for life, redeemed the land tax upon the settled estate during the life of the first tenant for life, and took an assignment to himself under the Land Tax Act. The prior tenant for life afterwards died without issue, having devised to John Lord Hampden the ultimate fee, and he, being in a dying state, and having no issue, made his will, and devised the fee of the settled estate, without declaring any intention with respect to the land tax redeemed. It was held by Sir John Leach, M.R. that the land tax at his death continued to be part of his personal estate. When John Lord Hampden, said his honour, took the assignment of the land tax to himself, that act amounted to a declaration of his intention that the land tax redeemed should be part of his personal estate. It could not afterwards sink into the real estate without his expressed intention to that effect, and there is no evidence of any such intention. It is difficult to reconcile this case of Trevor v. Trevor with the principle recognized in Forbes v. Moffat, and other cases, viz. that where a person becomes entitled to the inheritance of an estate, of a charge upon which he is also the owner, and it is indifferent to his interests whether the charge should or should not subsist. The presumption in equity is, that the charge will be merged. The case of Astley v. Mills, however, was decided upon the intention which was proved by evidence, but in Selsey v. Lake the charges were transferred to trustees as subsisting charges at law, and yet they were held to be merged. In Trevor v. Trevor it was immaterial to Lord Hampden whether the charge subsisted or not, and it is difficult to see how the assignment to himself of the land tax could be considered stronger evidence of an intention that it should form part of his personal estate, than the transfer of the charges to trustees in the case of Selsey v. Lake. Trevor v. Trevor is distinguishable from the case of Wyndham v. the Earl of Egremont. In the former there was an accession of the fee to the charge during the life of Lord Hampden, while in the latter there was a period during the life of the tenant for life in which it was indifferent to him whether the term should be kept on foot or not, and upon this ground the case was decided. The facts were these: a tenant for life, with remainder to trustees to preserve, and c. remainder to his first and other sons in tail male, remainder to himself in fee, became entitled to a charge upon the estate and died without issue and intestate, and it was held that the charge was not merged upon the ground before stated. In Trevor v. Trevor the fee was devised to the tenant for life, and 2 days afterwards he died, having made his will devising the fee of the estate, and the court held that as the charge formed part of the owner's personal estate when it was paid off, it could not afterwards sink into the real estate without an expressed intention to that effect. It is submitted that this rule, though highly reasonable when a charge is paid off by a tenant in tail in remainder, has no application when the owner of the charge becomes also the owner of the fee, and disposes of the same either by deed or will. At any rate, the case of Trevor v. Trevor must be considered as a case of anomaly. If the owner of a charge is desirous that it should still form part of his personal estate, it is advisable that he should express some such intention, either at the time of his acquisition of the fee, or upon his disposition of it. A charge, however, will not be lost if the person who pays it off is only entitled to the estate, subject to an executory devise over which takes effect. The principle of merger will also apply if a man purchase by marriage charges upon his estate as in says v. Price. There an infant was entitled to a sum of 3,000 litres, and to a bond for 200 litres charged on her husband's estate, and upon the marriage the husband settled an adequate jointure in lieu of these charges. Lord Hardwicke held they were sunk in the inheritance, and observed although the legal interest in such choses in action would vest in the wife by survivorship, and she might have an action at law for the recovery of them, yet a bill by the husband's representatives might be brought to have the benefit of the securities, and for the wife to stand as a trustee for them, and the court would not let her have those things which were purchased from her by her jointure. It remains to consider what will be sufficient evidence of an intention to keep a charge alive. The evidence may be by parole, and if it clearly prove the intention of the party, the charge will be preserved. The acts of the party in transferring and dealing with the charge may also afford direct or presumptive evidence that it was his intention to preserve the charge. Thus in Astley v. Mills, the evidence of the solicitor who prepared the assignment of the charges was admitted to prove that it was the intention of the testator that the charges should not be transmitted as a burthen on the estate. In Hatch v. Skelton, the owner of a freehold estate subject to a mortgage in fee to secure 1,300 litres, devised and bequeathed his real and personal estate to the mortgagee. In the residuary account, the mortgagee stated that he had retained 467 litres out of the personal estate towards payment of his mortgage debt. The mortgagee afterwards devised the property to 3 relatives of the mortgager, provided they undertake to receive the same with all the liabilities attaching thereto. The attorney of the testator was examined at the hearing, and proved that the testator considered that the charge was alive, and it was held that the mortgage had not merged in the fee. A contemporaneous transfer of the charge to a trustee will not be considered as of itself solely decisive evidence against the presumption of merger. Thus in Hood v. Phillips, where Elizabeth Lort, the owner in fee of an estate, paid off a mortgage in fee upon it, which was transferred to a person who, on the following day, executed a declaration of trust, whereby he declared that he held the 500 litres, paid for the transfer of the mortgage in trust for Elizabeth Lort, her heirs, executors, administrators, and assigns respectively, and covenanted to convey to Elizabeth Lort, her heirs or assigns, or unto such other person or persons, and in such manner, and form, as Elizabeth Lort, her heirs, executors, administrators, or assigns should direct. Elizabeth Lort devised the estate to a trustee to pay an annuity, and raise certain legacies and subject thereto to P.L. Phillips, his heirs and assigns forever, and upon or for no other use, trust, intent, or purpose whatsoever. It was held by Lord Langdale, M.R., that the charge had merged in the estate. It appears to me, said his lordship, that if Mrs. Lort really had intended to keep the charge on foot, the declaration of trust was an occasion on which the intention must have been clearly and unequivocally expressed, and the absence of any mention of the trust on which the money was to be held, or the mode in which it was to be applied, appears to me to afford evidence in support of the ordinary presumption, far outweighing any evidence against the presumption which the use of the words executors and administrators in an ill-drawn deed may be supposed to afford. There is nothing to show that Mrs. Lort had any interest in keeping up the charge, and thinking that the transfer of the mortgage and the declaration of trust taken together do not afford sufficient evidence to rebut the ordinary presumption, that she paid off the charge to relieve the estate, it does not appear to me to be material to consider what advice or what motive induced her to cause the transfer to be made as it was. And his lordship, after observing that from the terms of the will it was difficult to suppose that it was intended that the estate of the devisee should be charged with 500 litres, for the benefit of the residuary legatee, added, what the plaintiffs want is proof of intention to rebut the ordinary presumption in such cases, and the occasion of making the will was such as to make it probable, to say the least, that the testatrix would have distinctly and unequivocally expressed the intention if she really had it. If the charge had belonged to another person it would have been in no way affected by the terms of the devise, and even in this case, the charge belonging to the testatrix, I do not think that the silence of the will on the subject of the charge is itself conclusive, but it corroborates the impression afforded by the other circumstances of this case, and on the whole, I am of opinion that there is not sufficient evidence to rebut the presumption that this lady, having paid off the mortgage, intended to extinguish the charge. If the owner of an estate, and also a charge upon it, grant an annuity and make both the estate and the charge a security for the payment of it, that circumstance will not have the effect of keeping the charge on foot as part of his personal estate. Where a conveyance is made expressly subject to a charge, that of itself is not evidence of an intention to keep the charge alive. In Johnson v. Webster, the owner of the estate upon which there was a charge, settled the estate upon his marriage expressly subject to the charge. He subsequently became entitled to the charge, and it was held to be merged. In this case, however, the settler became entitled to the charge as residuary divisee under the will under which he also took the estate which he settled. If he had paid off the charge out of his own moneys, it would have formed part of his personal estate. Thus in Pears v. Waitman, copyhold lands which had been conditionally surrendered for securing certain mortgages were settled by the testator subject to the mortgages, he at the same time covenanting to pay off the same, and there was a proviso that as between the testator, his heirs, executors and administrators, and the persons entitled under the settlement, the lands were to be the primary fund for payment of the same mortgage debts. In 1826 the testator paid off the debts out of his own moneys, and satisfaction was duly entered on the court rolls. In 1831, the lands were, under a power in the first settlement, resettled by the testator and his wife, but no notice was taken of the fact of the repayment of the mortgages. The settlement of 1831 was held to pass the land as it stood with all its liabilities, rights and equities, and that the amount of the mortgage debts was to be considered as kept on foot as part of the testator's personal estate. A mortgagee's interest may be seriously affected by the merger of charges. Thus if a third mortgagee, having actual or constructive notice of a second mortgagee, pay off the first mortgagee, and fail to keep the security on foot, he is not entitled to stand in the place of the first mortgagee against the second. There being no declaration of an intention that the charge shall be considered as subsisting, it is held to have merged. If a transfer of the mortgage is made to a new mortgagee, without taking any assignment of the debt will be extinguished, and the securities will then rank according to their date. And so if a second mortgagee take a conveyance to himself of the equity of redemption in consideration of the debts due to himself and the other mortgagees, and he covenant to pay these debts, his own debt will be extinguished, and he will not be entitled to be paid his debt in priority to a third mortgagee. The refusal of the first mortgagee after being paid off to execute an assignment of the mortgaged premises contrary to his agreement, will not prejudice the party who has paid the charge. But if a suit be necessary to compel an assignment, subsequent encumbrances would seem to be necessary parties to the bill. The right of the person, however, who has paid the charge to have the legal estate seems undoubted. Equitable mortgagees of a leasehold interest will not be prejudiced by the merger of it. Thus in ex parte Whitbread Redix, the bankrupt was the lessee under a lease for 46 years, subject to a former lease for 20 years, and he deposited it by way of equitable mortgage. He afterwards purchased the remainder of the term granted by the first lease, and deposited that lease also with the same party for securing a further sum. It was held that the first lease was not, under these circumstances, merged in the second, and that the depositaries were good equitable mortgagees under both deposits, and if an equitable mortgagee, after notice of an act of bankruptcy, take a conveyance of the legal estate, his equitable mortgage will not thereby be merged, but will remain good, notwithstanding the invalidity of the conveyance. A purchaser, however, of an equity of redemption may now, by paying off the first mortgage out of the purchase money, and showing an intention to do so, stand in the first mortgagee's place against the next encumbrancer. The case of Toulmin v. Steer was considered an authority against this position. In that case Sir William Grant, M.R. observed, the cases of Greswold v. Marsh, and Mocatta v. Murgatroyd, are express authorities to show that one purchasing an equity of redemption cannot set up a prior mortgage of his own, nor consequently a mortgage which he has got in, against subsequent encumbrances of which he had notice. In the cited case of Watts v. Sims, before the Lords Justices on appeal from the Vice-Chancellor of England, Knight Bruce, L. J. Observing on these cases, and the doctrine deduced from them by Sir W. Grant, says, with the greatest deference to the authority of that eminent judge, I always doubted and still doubt whether the cases mentioned by him go that length. The cases were as follows. In Gwillem V. Holland, the mortgagee, having notice of 2 out of 3 subsequent judgments which had been confessed by the mortgager, took, after a decree for foreclosure, a conveyance of the equity of redemption, and was decreed to pay the 2 judgment creditors who had offered to redeem him before he got the foreclosure decree, and in MERGER v. Murgatroyd, the mortgagee of a ship returned the bill of sale to the mortgager, who thereupon made several subsequent mortgages of several parts of the ship, which were endorsed upon the original bill of sale, and some time afterwards the mortgager delivered up the bill of sale to the mortgagee, who made no complaint, but acquiesced in the mortgages. He afterwards took a release of the equity of redemption, and it was held that the subsequent mortgages should be preferred to his, because of his carelessness and acquiescence, and that though he had taken a release of the equity, it did not oblige him to pay the intermediate mortgages if he would waive the release. These cases, doubtless, were decided on the rounds of fraud and laches, and certainly do not warrant the inference deduced from them by Sir William Grant. Toulmin v. Steer therefore so far as it lays down the rule that a purchaser of an equity of redemption cannot set up against a second encumbrance or a mortgage which he has got in, must now be considered as overruled. Again, on the purchase of an estate from a mortgager who contracts to sell free from encumbrances, the purchaser is entitled, with the concurrence of the mortgagee, to require a conveyance of the equity of redemption, so as to keep the mortgage on foot. The purchaser, however, must bear any extra expense incidental to such a mode of completing the purchase. A judgment will not be merged by an assignment of it to trustees who hold the real and personal estate of a debtor for the benefit of his creditors. In such a case the trustees are considered as mortgagees or creditors upon the estate, having a charge upon it for the payment of their debts. An assignment of a judgment, however, to trustees, as the owners of a trust estate, would merge the judgment,